So this morning, for our second session of the morning, before we conclude, we have two great panels. This morning, we have our economic damages panel, and we are very lucky to have the two people, really, who are at the forefront of the controversy of the economic damages battle, at least in the Circuit Court for Baltimore City. We have Dr. Tony Gamboa, who is the author of and the founder of and the person behind the research surrounding what we all know as the Gamboa tables. And Dr. Gamboa is a vocational economic analyst, and he will be here to talk about the tables and the theories and principles behind the tables. We also have Dr. Tom Ireland, who, as many of you know, is one of the principal critics and principal witnesses against the Gamboa tables. And so when Frank Daly and Frank is not only one of the best trial lawyers that I know, I'm very happy to call him a good friend, and when he agreed to speak, we started talking, and Frank has been doing lead litigation. He's probably old. He's been doing lead longer than some of you are old, I think. And he and his office, and you'll hear from Lisa Morgan in the next panel, are among the best of the defense firms in the city, and we're lucky to have him. But when we were talking about this program, we said to each other, well, we got Gamboa and Ireland. Who wants to hear from us? So literally, we're each going to talk 3 or 4 minutes, and then we're going to leave it to Dr. Gamboa and Dr. Ireland to talk about the tables, and you'll hear from them. So if you look at the bullet points of the agenda here, it says motions in limine, disqualifying experts, things like that. And we are all facing lots of motions in limine, specifically with regard to the economist's testimony. And when I was thinking about this, I said, well, and for those of you from New York, I'm sure you've heard it enough times by now, we have a cap on non-economic damages in Maryland. In some of our cases, the cap is as little as $350. So to avoid that unconstitutional travesty of justice, what we try to do is put emphasis on the economic claim, because as someone pointed out, we think as plaintiffs that unless there's a horrible problem with the case, we're going to get the cap, and then it's up from there. So what these motions in limine are, I think these cases have turned from a battle of the experts to fear of the experts, because the economic damages are getting higher and higher. So rather than letting the experts battle it out in the courtroom, what the defendants are now trying to do is use motions in limine to keep the jury from hearing about the economic damages at all. So how is that accomplished? Well, you start out with a motion in limine, and in the Circuit Court for Baltimore City, we've had discussions about, well, when is this heard? Because in our court, literally the trial judge doesn't know that he or she is getting the case until we get the call from the assignment office saying, go to Judge Gordy's chambers. And Judge Gordy gets the file delivered, and 15 minutes later, we're in the courtroom, and he's got a 6-binder motion in limine from Mr. Getchy that he's expected to read and respond to. So there's been talk about, well, let's have these hearings ahead of time. As a plaintiff's lawyer, I would say don't let that happen, because it's not a Frye-Reed issue. It's not a Dalbert issue if that's where you are. There's nothing new or novel about it. So there's nothing to be heard. There's no such thing. Don't let the defendants as Andy Beta said yesterday, don't fall into the trap of the opponent's argument if you're the appellee. Don't let the defendants lull you into believing that this is some complicated Frye-Reed complex motion that you got to spend 12 motions in binders to respond to Mr. Getchy's 6. You got to convince the trial judge. It's a question of wait for the jury. It's admissible. Let the jury hear it. So really, I'm going to sit down. Frank's going to talk 3 or 4 minutes, and then we're going to get Drs. Gamboa and Ireland to talk to y'all.
Thanks, Brian. Folks, I had a birthday 2 days ago. This is the second time in a half an hour I've heard about it. First from my friend Mike Burgoyne, and now Brian. But no, I've been doing this litigation for a while, and I thought just sort of setting the perspective for what we're dealing with here. And for those who try, and like Mike, I enjoy my non-lead cases because they have more of a semblance of reality in the typical trial context. And these cases are different. They just are. But sometimes, as Dave Governo said, you step back and you look at the universe of what you're dealing with. You look at the big picture issue. And I thought to sort of lead into our friends here, I'd mention that just on the defense side, what we see are the big picture issues. And it helps me to look at my non-lead cases and to see what I face there on the economic damage side in comparison to the lead cases, same issue. And think about it, on the non-lead traditional tort cases, it's a different scheme, it's a different format. One significant difference is, and not always, because you do have, medical mal cases with injured babies, but in many traditional tort cases, you have to start with a history of earning, a proven, documented history of earning. So you have point A that is established that you can work from. Then you have an injury that's typically documented by a medical doctor, and you've got causation. And then you've got point B down here, which is typically documented by a vocational rehabilitation expert. The economist then just comes in and bangs the numbers out. I mean, it's pretty basic in many traditional tort cases. It's the difference between this known, given, nobody can dispute because we got tax records and W-2 forms, earned income. We've got an injury. Let's take a classic, steel worker loses an arm. Or steel worker, a little less specific, has a pulmonary issue, heart issue that just lessens their ability to perform. So you have a documented medical issue there that reduces their vocational capacity down to a lower level. And the voc rehab, very understandably, it makes intuitive sense to all of us, can say, because of this reduced earning capacity, we've got a lower level of earned income and expected earned income history. And that makes sense, and that lower level is projected, but it makes intuitive sense to all of us, for the most part. Okay, and then the economists bang those numbers out. What we have in the lead litigation, though, is both point A and point B are, to some extent, as a defense lawyer, I would say, speculative. Point A, we don't have, in most cases, an earning history. I know Mike alluded to in some of the cases, we might have a couple years of earning history. But generally speaking, these are, in many instances, plaintiffs who have never worked. So the top line is, what would these folks have done absent the lead exposure? That first line right there is filled with assumptions, filled with opinions. So that's the first level. Then we've got a medical issue that comes into play, and theoretically it's going to be a doctor. One of our friends is going to say, whatever the lead exposure was, it caused a reduction in earning capacity, reduction in cognition and cognitive ability, which is reflected in reduced earning capacity. And then we get to the bottom curve there. To our friends like Mr. Lieberman, all voc rehab people, then take that information and say, we can project earned income into the future because of this reduced capacity. So really in lead, we're dealing with, in most cases, two very speculative areas. The top line and the bottom line, we've got an injury that are probably both sides experts. I mean, we're going to fight about that for different reasons, but even if you accept the injury, you've got a top line and a bottom line that is filled with opinions, filled with assumptions. And as defense lawyers, what we look at is, and as Brian said, hopefully even before we get to jury, we can scrutinize what's there. And we like to try to convince the court that expert testimony is this incredibly high standard. If you ask the public, oh, it's got to be an expert from Hopkins or Harvard. The standard technically is very low. It's a very low standard. But under 5702, there is a standard. They've got to be competent. it's got to be subject of expert testimony, and they've got to have a foundation. So you look at each of those parts of that analysis, and there's a lot of questions in there. And what we hear often on the medical side of things is we're going to hear in a moment, I think, about work disability. We as defense lawyers say, well, what does that really mean, work disability? To get to work disability, don't you have to have a medical issue? Don't you have to have a kernel of medical testimony documenting the start of the disability? And as my friends, several of our friends out here know, you take that and that becomes an issue. When they categorize someone as severely disabled, as partially disabled, does that mean there's some type of corresponding medical situation? So those are the issues we pick up on in our motions in limine, and hopefully get some guidance from our two friends on each side. With that said. Sorry.
The reason I want to be close to you is that it is essential to understand that the issue is measuring earning capacity. You can measure earning capacity in a 1-year-old who has never worked a day in his or her life. Now, how can you do that? You can do that because earning capacity, or other language that's used in other states around the United States, is synonymous with what economists call human capital. Human capital is defined as the acquisition of knowledge, skill, and understanding, a result of education, training, and experience that allows you to sell your services in the marketplace in exchange for money, right? Everybody in this room possesses varying degrees of human capital. The precursors to human capital are twofold. All human capital emanates from intellect and physical ability. Those are the two fundamental building blocks of human capital. If you diminish someone's intellect through lead paint poisoning or through a traumatic brain injury as a result of a car crash, or if you injure someone physically and they have some diminution of physical functioning, there is a loss of earning capacity, and it can be measured. Now, that's the theory, but you know what the data tells us? Consistently, the data tells us the same thing. Disability, regardless of how it's defined, has two effects. The two effects? It reduces earnings on average across the board for men and women at all levels of educational attainment. That's not an opinion, that's a fact. What else it does is it reduces employment levels on average. Again, true for men and women at all levels of educational attainment. Again, that's not an opinion, that's a fact. If you have a client who sustains permanent impairment resulting in disability, whether it's a cognitive disability, a physical disability, or a sensory disability, resulting in a work disabling condition, there's a loss of earning capacity. Now, why do I say that as boldly as that? If you have compelling data that consistently tells you the same thing, and if you have a client who has sustained a diminution of either intellectual functioning or cognitive functioning, why would your client be necessarily an exception to the general rule of what we know about disability? There's nothing to cause anyone to conclude, in my opinion, that someone who has permanency of impairment is going to be an exception. Now, can you find a voc rehab person to come into a courtroom and tell the jury that this paraplegic, or, I've seen it, quadriplegic, has no loss of earning capacity because they went to college? They used to be a bricklayer. Now they are in college, they're functioning as an accountant, so there's no loss. That's nonsense. That's called a paradigm shift. What we know is that educated college-level people with physical impairment earn significantly less, and they have a significant reduction in work-life expectancy. Now, I'm not supposed to be talking about this. I'm supposed to be talking about work-life expectancy, so that's what I'm going to focus on. But I think you have to have the broad picture of what it is that's being measured. Work-life expectancies have always been controversial. They were first developed sometime in the 60s, I believe. Initially, they were specific to men and women. Also, you could have a work-life expectancy that would be specific to race. This is in the 60s. As time passed on, work-life expectancies published by the Department of Labor became a little more sophisticated. And they started examining work-life from the perspective of education level. In most states, there was movement away from the notion of examining a work-life expectancy based on race. Today, I think there are very few, if any, venues where that's done. And that's called a good thing because the best predictors of work-life expectancy are education level, gender, and age. Now, the more education one has, the greater the degree of work-life expectancy. There's a direct linear relationship between education and work life. The work life lengthens as the education level goes up. Persons with a professional degree, those who have a D after their name, as in JD, MD, dentists, they have the greatest work-life expectancies. Those with less than a 9th grade education have the lowest work-life expectancies. Okay? But nothing predicts work-life expectancy in terms of alteration. Nothing predicts it better than a physical or a cognitive impairment. This is what the data tells us. Now, let me ask you this question. How many of you in this room believe that persons with a disability, whether it's cognitive disability, physical disability, sensory, whatever, how many of you believe that they have the same levels of employment on average as persons with no disability? Who believes that? Put your hand up. You know better, don't you? Disability has a negative effect on employment. It decreases it significantly. In this contracting economy that we just went through, the first to be let go in the contracting economy, persons with disability. The last to be hired in an expanding economy, persons with disability. Again, it's not opinion, it's a fact. Now, if everybody in this room believes that disability reduces levels of employment, I think it's essential to realize that a work-life expectancy is nothing more than a statistic that tells us what the probable work life will look like in aggregate for an individual of a given age, education level, and disability versus non-disability status. It's nothing more than a combination of probabilities of being alive, employed. You can't be employed if you're not alive. So a work-life expectancy value is a value that simply takes all of the separate probabilities of being alive and employed from a given age through age 84, 88, depending upon what data set you're using. And when you sum that, that's what gives you the work-life expectancy in years. Does that make sense? It's not a series of continuous years that results in the work-life expectancy. It's a series of a chunk of each year, summed. So if I say to you a 50-year-old male has a work-life expectancy of 12 years, you might say to yourself, well, does that mean they're going to stop working until at 62? No, is the answer. It means that in aggregate, all of those separate probabilities produce the work life. That same 50-year-old male with a cognitive disability may experience a reduction of work-life expectancy of approximately 5 years. When people argue about and suggest that the data emanating from the Census Bureau shouldn't be used, that's malarkey, Tom Ireland. And you know what malarkey is, because you're Irish, right? It is a fact that on our website, we have 7 appellate court decisions supporting the lower courts in allowing testimony from our experts specific to the issue of reduction in work-life expectancy. There has never been, to the best of my knowledge, any appellate court decision that says you can't use this data. And I think I would know if there have been such decisions. I'm not aware of any judge at a district court level saying, we're not going to allow this testimony now because the data is no good. Now, have there been persons who've misused the table? Sure. People misuse the tables, especially early on. The table's been revised 7 or 8 times since '87, when I first developed these tables while serving as a professor at the University of Louisville. We fell into this data by accident, is basically what happened. Now, of the 7 appellate court decisions that are on our website, there's one you have to read. You can read it by simply going onto our website, www.vocecon. Vocecon is an abbreviation for vocational economics. www.vocecon.com. Hit the resources tab, and then hit appellate court decisions. The last appellate court decision came out of New Jersey. You have to read it. It's superbly written. It gets perfectly at the issue of diminution of earning capacity or reduction of human capital. Here are the actual earnings of this man, who was only 31 years of age. $900,000, $1 million, 121315. I'm not exaggerating. He was a hedge fund person. Those earnings, all after he sustained a traumatic brain injury. After. Did he have a diminution of cognitive functioning? Sure, he did. Neuropsychologist, the medical, solid as a rock. The only argument was he obviously couldn't have any type of earning capacity loss, making that kind of money. His dollars were going straight up. But that ignores a very, very basic fundamental fact. You know what that fact is? The aging process by itself starts knocking off brain cells. You're not as sharp at 67 as you were at 37. Now, I know that because I'm 67, but you know what else? When you have an interaction effect between a brain injury and the aging process, the decline intellectually is much more precipitous. People want to talk about what happened from the date of the injury to the date of the trial. The trial should be about what is likely to happen from the date of the trial through this person's life expectancy. So with this particular Natowski case, when I talked to him, the first thing I said to him was, how long did it take you to find an attorney to take your case? He said, well, he said, I interviewed 17 of them over a 3-month period of time. And he said, I finally found this attorney in Princeton, New Jersey named Bruce Stern who took my case. He said, and I felt so badly when he said, I want to take your case because I said to him, I don't want to get you in trouble. The managing partner of this firm told me about a month and a half ago that I didn't have a case. Okay? That appellate court decision and that district court judge, only district court judge, by the way, that I think I've ever appeared before who had a degree, a law degree from Harvard and an undergraduate degree from Harvard. The appellate court decision supported the lower court in allowing a $3.6 million jury verdict based off of one variable. You know what that variable was? Take a guess. The guy had a master's degree, okay? Right? Persons, men with master's degrees or baccalaureate degrees and beyond, they experience a reduction in work-life expectancy. That $3.6 million reward resulted because, one, the plaintiff's attorney is extremely sophisticated with brain injury, and two, extremely sophisticated with the government data that we use. Now, was that $3.6 million jury verdict excessive? I don't think so. And the reason I don't think so is this. When you're looking into the future, you're relegated to a position of having to use statistical averages, which is what a work-life expectancy is. Do I think this man as he passes through the 50s and 60s, is going to stay in the labor force as long as he otherwise would have? I do not. Hence the reason for the reduction. Where am I on time?
About 2 minutes.
Okay. The issue of work-life expectancy has been attacked basically from 1987 on. The success of the attacks, however, have, in my opinion, been non-existent. Okay? And when people talk about peer review, it seems to me that 7 appellate court decisions emanating from 4 different states is the type of peer review that's best. Thanks.
Should I just go ahead and lead it?
Yep.
Okay, well, let me start for the limited humor that I'll manage to generate with the visual aid that I brought with me, which really speaks to a lot of what I'm going to talk about. Best available data sometimes is not good enough, and it doesn't convey what it is that we would like to know. I want you to leave you with that, and I want to also leave you with a second part of that, which is that just because a calculation is based on government data doesn't make it useful or reliable or accurate for the purposes for which it is being used. The problem, in order to understand what we're dealing with, I want to start with work-life expectancy, and I know that all of you are pretty reasonably familiar with it, but what we are talking about with work-life expectancy is we're taking into account the fact that if a worker has been injured, we can't just calculate his loss of earnings through infinity. We have to reduce it based on the fact that he's going to die. We have to reduce it based on the fact that he's going to age. We have to reduce it based on all sorts of other factors. He might be injured, he might be ill, he might reach a point where he's unable to continue in the labor market, and so forth. Those factors don't just apply to disabled people, they apply to everyone else. And I was sort of laughing at when Dr. Gamboa talked, when he talked about the aging process that works with disabled people, because at the age of 70, I'm well aware of some diminution in my physical capacities as an economist. Fortunately, I'm in an occupation where I don't have to be as physically able as in other areas, and in which human capital can continue to collect for a period of time, perhaps longer than with other people. A lot of what Dr. Gamboa talked about, I agree with. Education is the central issue with most work-life expectancy. But the issue of work-life expectancy itself is not really controversial. Good economists, good economic experts all take it into account. Granted, there are some people out there who simply project to age 70 or to life expectancy and try to sell that in a litigation context, but that's not what the standard, generally accepted feelings are of people who do the kind of work that Dr. Gamboa and I both do. We all believe that work-life expectancy is important. We all believe in the basic reasons why it's limited. You might die before you reach any given age. You might be injured before you reach any given age. You might become ill and unable to work before any given age. And ultimately, you will choose to retire. And aging will eventually reach the point where it forces you out of work. All of those things are pretty much taken for granted. The question is, what do we actually know about work-life expectancy? And there's two senses of knowing. A lot of what Dr. Gamboa talked about is accurate. I mean, we do know that disability probably in general causes people to have a shortened work life. We also know that disability in general probably causes people to have lower earnings. In most cases where I'm working, we have a lot easier, and this picks up on what Mr. Daly said to lead in, Frank Daly said to lead into this program. We have a pattern. We know where the person starts. We have some level of knowing where the person is after the injury, and if he's still got some what we call residual earning capacity, then we take that into account. The problem that we are talking about is the work-life expectancy for the residual earning capacity. If a worker is injured and we have some plateau and say, here's what he could have earned before the injury, we have another plateau that says, here's where we think he will start after the injury, we now have a differential. We can project the value of that differential over a work life. It is possible, but not necessarily true, that disability will shorten the period over which that residual earning capacity will actually take place. And it is with respect to that residual earning capacity work life that we have the controversy. So work life expectancy is not a controversy, not an issue. The question is, what reasonably and accurate answers can we give to the questions? There is a lot about work-life expectancy we would like to know. We do know something already. We know that age, we know that sex, and we know that education matters. And I agree with Dr. Gamboa with respect to race. None of us much pay attention to race. It was in the original tables. When I say none, there are a few people who take it into account, but I don't. Those factors are things for which we actually can measure reasonably accurate and reliable measures of the average result that a person's likely to have when he or she finishes an education. Now, we do get into problems. For example, we have an individual who maybe was at a high school degree when he got injured and now he's earned a college degree. Now, how do we use the tables that we've got because he was injured as a high school graduate, now he's got a college degree, what is his work life? How should it be assessed? That we're not going to get into here, but it can matter in that sense. The problem is that there are a number of other questions, and the two key questions that we don't have reliable and accurate answers for are occupation. Occupation can influence work life, but we don't have occupational statistics that will allow us to say what work-life expectancy should apply to that given occupation. We do know in some specific circumstances, like people who work on oil rigs or people who work on barges, that their work-life expectancies are shorter, but we don't have reliable data to know how much shorter by that occupation. Surprisingly, for railroads, we actually have fairly reliable work-life expectancy data because the actuarial evaluations of the Railroad Retirement Board allow railroad work-life expectancy calculations to be made. But those figures aren't quite comparable to what we ordinarily mean by work-life expectancy because those calculations we can make from the actuarial evaluations only are what is the person's work life in the railroad industry. It doesn't include possible post-railroad work life because that's not something that the Railroad Retirement Board has been particularly concerned about. So while we know we would like to know those facts, we know that we don't have reliable information about that. And the problem with disability is that each disability would have its own kinds of effects on how much it reduced anyone's post-injury work life. We know that some disabilities are going to reduce work life, some are going to reduce it, even a few may increase it. If you're knocked out of an occupation where you would probably not have worked in it that long, you may actually even have an extension. Though I've never seen anyone argue that in a given case, it's certainly possible. But certain disabilities will not matter depending on which occupation you're in. If you lose, as I like to refer, if you lose a little finger and you're a concert pianist, it'll knock you out of being a concert pianist. It won't reduce your work life for purposes of being a piano teacher, probably, because you'll be able to do something of that sort and be involved in teaching music in school and so forth. But loss of the little finger does not automatically reduce your work life. You may have a heart attack and it knocks you out of your original occupation. It may shorten your life expectancy, but it only shortens your work life expectancy through shortening your life expectancy. Each possible disability is going to have a different kind of impact on how long you're able to work after an injury. And the unfortunate fact is we don't know how much that is for more than a few individual medical conditions. H1 could be studied in great detail, but those kinds of statistics don't exist out there and are seldom brought to bear in actual cases. Where the controversy arises then with respect to why Dr. Gamboa and I are both here has to do with specific tables, work-life expectancy tables based on disability, and by the way, on non-disability, but I won't go into the non-disability part, that are prepared by Dr. Gamboa's vocational economics organization. They do rely on two surveys produced by the government, the Current Population Survey and the American Community Survey. I don't have questions about the validity of those surveys, but I do have real questions, as does the Bureau of the Census and the Bureau of Labor Statistics, about the use made of those statistics to measure particular categories of disability. You can find statements at the websites that say that they're not reliable for that purpose. And that's one major factor. But there are three reasons why most forensic economists I'm aware of, and what we see in surveys, do not use and are not willing to use the statistics that come in the form of the Gamboa-Gibson work-life expectancy tables. First, we have more than one method. There is an LPE method that's actually used in the compilation of the the Gamboa-Gibson tables, and this more standard Markov model, which involves calculations of transitions. We have two different methods for calculating work life that most economists accept as reasonable, applied to most categories. And by most categories, I mean by education, by sex, and by age. We can figure out work-life expectancies. What we cannot do is take into account disability by simply assuming that all disabled people have the same kind of consequence. The surveys were not designed to measure disability. There are 6 questions that are taken into account in deciding how to compile the Gamboa-Gibson tables, but that's not what those surveys were designed for, so it's not the right survey. That's number one. Number two, the LPE method, while generally accepted, is not an accurate method once you introduce disability as an additional category, because a person's sex doesn't change. It's seldom true that a person's education changes. A person's age is dictated by facts about that person. Those things are relatively immutable. But a person who is currently not disabled, and all of this depends on self-identification, may become disabled in the future, may become not severely disabled in the future, may become, and if they are not severely disabled, may reach a point in the future where they would say they weren't disabled. The statistics used, what happens is that people do transition back and forth between these disability categories. And averaging everybody doesn't capture the specifics of given individuals. But even if those two things weren't a problem, the final and most important problem is that the tables themselves assume that we can somehow lump all disabled people, categorized however you want to define the categories. It would be like saying we could come up with tables for tall people versus short people or any other kind of arbitrary distinction. Yes, disability can and often does reduce work-life expectancy, but no, it does not do it all of the time. And no, an average for all people who happen to fit some broadly defined category do not fit the circumstances required for reasonable accuracy and reliability for most purposes, and particularly including, I think, purposes in litigation. I have written about the work-life, the other issues, whether the LPE model is the best way to calculate work-life expectancy in papers that are available at my website. You'll find my website listed on my CV, and I welcome you to all look at those different statistics. one of those papers deals with the question of how long how an economist might deal with this. And it basically sets up a model saying, given that we don't really know how much the individual's work-life expectancy has been shortened, but we know there's a reasonable probability it has been shortened, here is how we can help a jury figure out how much it has been, make its own decision as to how much it's been shortened based on all the evidence provided in the trial. I think actually that is going to pretty much bring me to the end of where I should stop, and hopefully we can have time for a couple of questions.
All right, thank you. So, go ahead.
We were asked to mention that, and I say this respectfully to Dr. Gamboa, that none of the cases addressing the Gamboa tables that are addressed did address the issues of methodology that Dr. Ireland referenced and has been raised on some occasions in our jurisdiction in Maryland.
And
Yeah, can I respond to that?
sure.
Absolutely.
We're talking methodology. There's a federal appellate court judge whose name is Richard Posner. He's out of Chicago. Some of you, I'm sure, are very familiar with Judge Posner. In 1982, a decision was rendered. Judge Posner was the author of the decision. And in his inimicable fashion, what he did was not reverse the lower court, but simply point out what the economist should have done on the case. The case is called O'Shea versus Riverway Towing. And O'Shea was a woman who was about 55, 53, somewhere in there. Her husband had died. She had never worked a day in her life, but she decided to go back after the death of her husband as a cook on a boat. She sustained an injury, and with that injury, she was no longer able to function as a cook on a boat, but she could still do sedentary work. And here's what Judge Posner said. He said that the economist should have taken her earning figure and discounted it based on the probability of her being alive and employed, and that's pre-injury. And post-injury, the economist should have done the very same thing. Factored in what she could earn. He used minimum wage as an example and said that needed to be discounted based on the probability of her being alive and employed as a person with a disability. That's the methodology that resulted in the development of the work-life expectancy tables. The LPE method is generally attributed to Brookshire and Cobb, two economists. The O'Shea versus Riverway Towing decision came out a year before they wrote their article and for the defense. Whether they knew about the decision or not, I don't know. I never asked them.
I think Dr. Ireland wants a word.
Yes. Actually, the case of O'Shea versus Riverway Towing is an excellent case to read, and a lot of people have conjectured that the U.S. Supreme Court, in making its decision in Jones and Laughlin Steel versus Pfeiffer, actually followed a great deal of what Judge Posner said in that particular decision. It happens that the economist for the plaintiff in that case is Leroy Grossman, who was my traditional colleague in St. Louis. And I've run into the attorney who had retained Leroy at various times, so I've had a lot of familiarity with it. And there's no question that Judge Posner did talk about the fact that the individual's work life should be one of the things that might be addressed, but he didn't talk about how it should be addressed in the senses that really matter. There have not been any hearings, to my knowledge, in any court decision, and I regularly review court decisions. I run searches every day on the word economist, economic expert, and hedonic. I won't get into why I say hedonic, but I run those every day to just see what court decisions are coming down. There have been decisions which have refused to disallow the use of the Gamboa-Gibson tables, but not in circumstances where the tables themselves were subjected to a complete Daubert consideration or a complete Frye consideration or Frye plus and all the other variances that we talk about. That issue has yet to be addressed. In my opinion, when a court is presented with all of the evidence, it will rule that these are not allowed. I saying I guess I have a minute, but
Does that mean that those 7 appellate court decisions?
Well, let's not have a debate.
We're incorrect?
all right? So I do have one other question really quickly for Dr. Gamboa, and we have to move on to the next panel. When you use the term cognitive disability, does that mean it must fit the definition of disability as it's defined under the ADA?
Cognitive disability is defined as existing when an individual has limitations associated with learning, remembering, or concentrating. That's as close as you're ever going to get to data specific to persons with mild traumatic brain injury, because it's impossible to go in and examine each individual in terms of the degree.
Thank you very much. You can bring up the next panel, please. All right, so.
Brian, thanks. Take care.
Thank you. Thank you very much for your time. All right. So,
Nice seeing you.
Morgan.
Take care. Take that up.